very much, Kulani. Good evening, everyone. Good evening, madam. It is a great honor to share this panel with you as a moderator. I think I have manifested this in my life. So when listening to Kulani's introduction to you, I'm just wondering what a giant character that we have today, and how privileged are we to listen to you. Madam, before we get into the brass track, would you like to make some few opening comments on today's topic, bridging academia and law through the eyes of a legal academic? Madam, over to you.
Thank you, Chaturika. Thank you very much also to Ms. Indika Nagavatta, Chairperson of Women Lawyers Association, and her team, including you and Chaturi, for organizing this Q&A session, which will enable me to link with so many women in the legal profession, in academia, in the legal practice, and of course, in the judiciary. I hope we have a nice range of participants because I look forward to this conversation. Of course, I have another special connectivity with the moderator, Chaturika, because we are both first-class honors graduates of the University of, in my case, University of Ceylon, in her case, University of Colombo, but we have a connectivity. And of course, also this is intergenerational connectivity because I'm an octogenarian graduate and she is, I guess, what we call the Gen Z. Now there's a Gen Z 2 and 1, and I don't know which she belongs to, but still it's a nice intergenerational connectivity. Also, we can consider ourselves in that sense sisters in law, because we're all women here gathered together to talk about our engagement with this wonderful discipline called law. So thank you for arranging this, and thank you to the Bar Association and its president for having this concept of a conversation, with a broad range of participants on issues of concern on law, justice, and law teaching. I just wanted to make a few comments on this theme itself, because it is focusing on the connectivity between law and academia. And it interested me because what do we mean by academia? Academia we associate with teaching and with research and with study. And law is, of course, the discipline of law. Now, actually, in my experience, this distinction is also something which we need to query, because lawyers have to engage also in their own work, in practice, in the judiciary, in research, and also in writing. So those facets of work which we associate with academia, which is reading, writing, research, are also part of the legal profession, very much a part of it. And then when you look at the discipline of law, actually, it goes beyond teaching and academic exercises, because it links to so many other areas of work. Law is what I would think is a central science, central to certainly humanities and social science disciplines. And in that sense, a discipline that connects with so many other areas. And specifically, of course, it connects with law practice and judiciary, but it also connects with public policy and public administration. Law connects with the corporate and private sector. And now, in this new IT world, certainly it connects with other disciplines, be they medicine, not only just forensic medicine, but also IT and technology. So the discipline of law is so broad and wide that, in a sense, we need to rethink on whether there is an intrinsic link between academia and law, and that academia and law flows in a seamless connectivity with the profession. So I want to give that perspective to you too, so that we don't think in terms of academia is something else and the legal profession as something else. In fact, Some great lawyers and judges have been academics. We think of Professor Christy Veeramantri, who came from law practice to the judiciary, and he's a well-reputed scholar. So many others with academic links who have been great lawyers. So also their contribution to legislation, to public administration, to public policy. And therefore, academia in itself is not something separate, in my view, from the legal profession. Why then do we tend to think that there is this difference? I would like to put it to you that this is historical. And that is because in the colonial legal education heritage, which we have not changed in 76 years, we bifurcate between academia in universities, academics, and the legal professions entered in the law college. Now, this is just an accident of history because every other country in the Commonwealth has long shed this bifurcation. And you have universities which then have courses in law. And when those are completed, I'm talking of the Commonwealth countries which have background or colonial legal heritage on legal education. So I'm excluding other countries like the USA, Australia, Canada, which also do not bifurcate in this way. Other countries with a Anglo-American or common law tradition. But certainly even in those countries with the Commonwealth, this has been shed long ago. So everybody goes into university, like in the USA, Canada, Australia. And then there is a process of certification, like in the case of medicine or whatever it is, with some practical training and a course. And in many countries, they're called the bar exams. So you don't go to a separate institution, you do that. Now, I think as we discuss this theme, I'd like to flag an issue of concern, a total system change in legal education. And that system change, to my mind, should be, I know there's a lot of emotional attachment to Law College. It's a great institution of over 100 years, 150, 60 years. And therefore, there is a sense of emotional linkage to that institution. But today, you have so many private institutions teaching law. So why is it not the right time for the law college itself to become a degree awarding institution? So the law college too creates a path for obtaining a law degree. And the public universities, the private university, the law college also a private institution then, which will also be fee living as it is now, no different, then produce graduates who then have to complete a professional certification course and practical training. And that, I think, could be done by the Council of Legal Education and also the bar. And I hope that that kind of change will be contemplated so that we won't have to have another seminar on exploring the links, Chaturika, between academia and the profession.
Thank you, madam. Listening to you for like, I think it's just 2 to 3 minutes that we have started. Whenever we talk to people who know you closely, they say if you talk to Professor Savitri for 2 to 3 minutes, like you have materials to think for years. I think that is proven correct. So, madam, now let's move to the agenda or the questions that we have prepared for you, madam. Firstly, I would like to ask, you're coming from an era where women are not um, considered as like breadwinners. Sometimes they are not meant for the profession. I don't agree with that personally, but that's what we saw in that era. And what motivated you to choose legal path? Was it an intentional selection, or was it motivation that you got somewhere from your family? What motivated you, madam? Madam, you're mute.
Okay, that's okay. I'm sorry I have to disappoint all of you because we were sons and daughters of independence. And I was in primary school and university, and I can like to consider myself as a daughter of independence with this wonderful CWW Kannagara gift of an access to education. So having gone through this process uh, of getting that education, then in some ways, the question of why choose law didn't really surface. It was, in a sense, just accidental. Why? Because I was an art student. I did well in my university courses. I won a scholarship, one of three in the arts faculty. But that particular year, we had a choice because the requirement of Latin for law was dropped for some reason. And therefore, art students could transfer to law. So I was an art student. I wanted to do history. That was really what I wanted to do. I also wanted to do architecture, which there was no facility for. So then I thought, well, why not try something different? And so, in a sense, accidentally, and not with any idea of joining the legal profession or having a legal education, I came into the Department of Law of the University of Ceylon. Yes.
Ms. Chakrika, you're muted.
Sorry. Sorry about that. So, madam, your story has been a guiding light for so many of us. Could you reflect on your early education at the Ladies' College and how your formative years shaped your vision and confidence to step into the legal field?
Again, I have to say that I really can't say is at all linked to this pursuit of a career in law. But maybe yes, leadership, because I went to a private school started by missionaries who were actually came to Sri Lanka to start this educational institutions as suffragettes during the period of the suffragettes who were challenging the discrimination in their own country. So consequently for them, education was a good that they had to be shared with girls. And therefore, their whole ethos was to give a good education and also focus on the leadership skills of girls. So I was fortunate in that regard, but it was not really in a broader sense or narrow sense connected to the study of law. But today there is this discourse that we in this country have had 77 years of හත්ත අට අවුරුදු සාපය. I think that's completely wrong. Because actually, at independence, we had put in place those wonderful policies of access to health and education, which made an enormous difference to the female population of this country. That is what gave access. And that access also came not entirely through English. That's also a mistake to think that that the early independent years of independence were elitist. No, because the Kannangara reforms had created a track of private schools, plus also the Madhya Mahavidyalayas. And those Madhya Mahavidyalayas, a national school, gave an excellent education. I remember my friend, late Dr. Vimala De Silva, saying how she and her husband went as principals to Ibbagamo Central. And Minister Kannagara told them, go into the national schools and create centers of excellence. And those centers of excellence, therefore, emphasize bilingualism in education, not just access to teaching and learning in Sinhala or Tamil, but English also. So in primary school, the policies of that time required us all to be in different language media. It was called vernacular education in Sinhala and Tamil. So from grade 1 to 5, we were totally immersed in Sinhala or Tamil. But we had a huge focus on English. English was taught every day in an exciting, interesting way. Some of us came from bilingual homes. Others may have come in the national schools, especially from only Sinhala or Tamil educated homes, but they picked up the English. So in grade 6, hey presto, we were asked to all study completely in the English medium. And that was done. So the primary school education, therefore, that we had, it was not monolingual, it was bilingual. It gave us a gift of this wonderful access to a good education. And I want to emphasize that this was not some elitist exercise for the private sector, for children who could afford a private education, but a national policy. So this was really the context in which I had my early child education. And so therefore, when I say that law is what I call is a central discipline, then those gifts of a good education plus a focus on women in leadership or girls in leadership perhaps impacted my later career.
Thank you very much, Madam. I believe that there are many colleagues who are in the legal fraternity now are products of pre-education, and we all are gifted in that sense. So, Madam, let's move to talk about your university education, because when we hear about early university, that the movement that happened to Peradeniya to Colombo are so different, and the context and the classroom modalities and the combinations are so different. So those are fun stories that some of our senior colleagues share with us. I would like to hear from you about your university education. How was it? Like, what was your experience?
So Chaturika, again, as I said, we were the fortunate generation because we entered university without the competition, the terrible competition that succeeding generations had to face. You could offer four courses and get into the university with 2 courses, right? And your list of newly admitted students came in the newspapers because the whole first batch was like 350 students, right? Just imagine that. So in a sense, we were very privileged. But as I said, it was not a privilege of wealth, but it's a privilege of access to education, right? So we all came into university. I went into the Faculty of Arts, and I said rather accidentally, I changed. I focused on entering the law department and then to read for a LLB degree. And that university education, the department was located in the Faculty of Arts. And the Faculty of Arts at that time had wonderful scholars, inspiring teachers. So this whole concept that, we have had 77 years of is wrong, because the university produced excellent scholars, academic students who made a career path for them in many areas. And that was because the focus was on the excellence in education, in the teaching, in the learning environment. And again, the issue of gender. We had a wonderful batch of 25 men and 5 women. And I have to say, it was a wonderful collegiate and an environment of companionship. And of course, some people fell in love and formed their partners. But for others, it was a wonderful, wonderful environment for learning without a sense that we as women were some kind of different species. So much so that when Professor Nadraja would teach his contract law and talk about the incapacity to enter in contracts, and he read out this list of persons who had incapacity, which was minors, persons with mental incapacity, and women. There was only a slight titter in the class, and it didn't affect us girls at all. We sort of looked down the length of our noses because we didn't think it was at all relevant to our lives. So, consequently, it was a very happy experience in one of the most spectacularly beautiful campuses of the world, in a rich intellectual environment where we forged friendships that have lasted a lifetime. So I think that is important to reflect on those early years in the University of Ceylon, Peradeniya, where law was taught as just one discipline in the Faculty of Arts, and therefore there was connectivity to the Faculty of Arts in a general sense, and we benefited from that in getting a broad education. Then again, the university education itself uh, emphasized the concept of freedom of speech. And there was wide range of ideas. In fact, there were university staff who had actually uh, political sessions for their students. The red and the left uh, dons used to have classes for their political for their students, introducing them to Marxism, etc. And some of them became lifetime socialists, I dare say, right? Then there were the others, on the other hand, who didn't do that, but had the kind of maybe what you would have called the right politics in today. Then again, ragging. It's sad because we had a wonderful person on the staff who went on a single-minded campaign against ragging, and we were beneficiaries. So we didn't have ragging. And it saddened me because in 1998, the Minister of Education invited me to chair the committee that drafted the ragging and violence against the legislation on ragging and violence in universities and educational institutions. And that was when they have a horrendous physical violence and mental violence in ragging in the university. So it saddened me that I had been so privileged. And then so many decades later, everything had changed so much. And again, the staff student relationships were also very good because the classes were small, interaction was easy, and that was also a great gift. And of course, the library was central to our education in university. And Peradeniya University had a wonderful collection in not only in law, and we students had what we call library peons or messengers who would track a book for us. And or you have heard of the Roman jurist Alpia. So one of them was actually called Alpia because he was so good at tracking our books. So reading in the library was part of our learning, and everybody wanted to do the reading. And library was open till 10 o'clock at night, and it was used. So in that sense, the education that we had right up, I would say, to the 60s, late 60s, when we transferred to Colombo, was that kind of environment. And I think it is epitomized in something the late Lakshman Kalligappa said. He was a distinguished lawyer, he was a distinguished foreign minister, and then he had established a career in his University of Oxford as a postgraduate student. And he said, the icing on the cake was Oxford, but the cake was baked in Sri Lanka. So that about says what it was like with Ulika.
Thank you, madam. The only difference that I see is when I entered the faculty, we were the majority. There were 80% of female population students in the faculty. So in that sense, there's a difference where the era where I entered the faculty, and library was not in the faculty building during our period because we had to go to the main library. So, but it's very wonderful to listen to these stories where we can also connect and we can imagine how it was, how it would have been for you all. And madam, so becoming a law academic is not necessarily a easy task, and sometimes it is not in the map also for some law students. So, but now you have become, you mentioned several times it is accidental. I was thinking in my head, what a beautiful accident that was. Good that accident happened because now we have you as the living legend of legal academia. So, madam, going back to your journey as an academic, so your work has always inspired us. But I would like to ask, what can you tell about your journey so far in the academic field? Because I read somewhere that it was not your intention, because your first year was little tough as an academic and you wanted to join the central bank at one point. Is that correct, madam?
Well, yes, that's a personal detail, and I will tell you the reason for that. The reason was that I had this very wonderful experience of learning in as a student in the University of Peradeniya. And again, I think this is interesting because if you ask me what was my journey in academia, uh, once, like you, Chaturika, when you do well in your LLB degree, you immediately think of postgraduate studies, right? I think you did. I think you and many others in this group have done that. You think, okay, after I've got my degree, I want to go into postgraduate education. And that's what I thought too. And of course, again, the path was open because we had two important scholarships which were available. And I think they're still available as a career path to the younger uh, cohort of LLB, of law graduates, and also those who pass out from law college, which was the Fulbright program and the Commonwealth program. Now, I applied for the Commonwealth because I had privately, my father was from Cambridge and he was very keen that I should go to Cambridge, and I had already got a place in Newnham College, Cambridge. So I applied for the Commonwealth, and I also applied for the Fulbright, which I think is something that everybody does even now, right? You apply for whatever scholarship is available. I did so, and unfortunately, I was selected for the Commonwealth, but I didn't get it. I went to the Fulbright interview and I said, I have got a place in Cambridge. I have applied for the Commonwealth scholarship. And if I get it, I will go to the UK. And miraculously, that board didn't cancel me out because eventually I got the Fulbright or the Smith, it's not called the Fulbright, it's called the Smith scholarship to Harvard. Now, I was excluded from that scholarship that I had won. That happened to other people. And when it happened to other people, there was one person who thought that there was discrimination on the basis of ethnicity. I also could have thought it was discrimination on the basis of gender because the other people who later got the scholarship were men. But the fact of the matter is it had nothing to do with gender or with race. It was something which we see today, a pulling of a string, an abuse of power by a particular individual. So we have to not, we have to not change the discourse to suggest that there is some kind of discrimination on the basis of gender, or that there was in that instance a discrimination on the basis of gender or on the basis of race, in the case of some other people, some other person. But it was just abuse of power. Right? And that is something we must all contend with up to this day, and we must address. So postgraduate education, therefore, was a path. And I did my postgrad, had a wonderful experience. I went to Harvard, and it opened enormous opportunities for me, not in terms of not in terms of career, but in terms of my own intellectual growth. And every time I have students who want to go to postgraduate studies, I tell all of them, go to American universities. And so it is with a profound sense of sadness that I see what is going on in the US today, where universities are being pressurized to completely discourage freedom of thought, expression, and research. And it is deeply saddening as an octogenarian to see this enormously negative shift. And I do hope with all my heart that their sanity will prevail. And for example, the case against Harvard will be decided by the Supreme Court to establish and entrench First Amendment rights. Because universities as centers of learning must prevail for a country to progress. So I walked into a post in the Department of Law. Nobody said, "You're a woman, you can't come back." In fact, I got a telegram to say, "You have been appointed assistant lecturer in law." And when I got that letter, my American friends said, "My goodness, Savitri, how did that happen?" It would take years for us to get a faculty position. So it was not a hatta hatta avrudu saapiya. It was access, which the Kannangara ethos of education had given all of us. So I walked into the job. But Chaturika, I did apply a post in the central bank. Because when I came back on the staff, it was another matter. We didn't feel we really belonged because it was very male oriented. There were fewer women. I missed my friends, my family, etc. And I didn't like the Peruvian environment. We had to live in hostels. We had no accommodation. And I must say the teaching, I liked the teaching, but it was not that great for me to say I want a career in academia. So I did apply for the central bank job. And I remember the late Kamini Kuria interviewed me. And I went into the interview with my degree certificate folded neatly into a white handbag. And all the other men there were carrying their degree certificates framed. So he said to me, "Miss Elafola, you have carried your certificate in your handbag. Everybody else has framed." And that was so funny. I got the job. But again, I changed my mind and decided that I would stick with academia. So that's how I stayed in academia. So that's a true incident, but that's the background to it. And that's how I came into academia back again after postgraduate, like many of you did. And from there, of course, then it was being immersed in teaching and research.
Thank you, madam. So now let's talk a bit about the interconnection between practice and academia as well, because we see, as you said, sometimes there's a bifurcation, like practicing lawyers are different, like academics are different, and we have our own little cocoon to live in. And madam, do you think that should legal education place greater emphasis on practical skills alongside theoretical knowledge as well? So eventually it will mold better like law graduate as well as a budding lawyer. So what is your take on this matter?
Chaturika, my own reflections and perceptions of this issue are very much located in what I tried to say at the beginning. In my own career and in my life and experience, I question the validity of this distinction. Because, as I said, law is a discipline that takes you into so many, many areas. And it is a disadvantage of our colonial heritage on legal education that continues to make us think as if we were academics and if we were lawyers. So then, when curriculum review is done in the universities, suddenly everybody says, "Oh, must put this lawyering, practical training skills, because our students must go and practice. And then when they practice, if they are in academia, they don't get this." This is wrong, because in other universities, as I said, you do your academic training, and you do your bar exams, and then if you go into practice, you acquire those skills. You don't need to learn them in the classroom. And of course, you can have clinical legal education. You can have lots of community work, which involves law. We have different kinds of interesting programs where you go outside the classroom. But I do not believe that legal education should be bifurcated and said, "Okay, you teach X number of subjects which are core, X number of subjects which are into practice," because practical skills must be acquired. I myself studied evidence as an undergraduate course. I loved it. It was a wonderful course to take, but it was not practically oriented. It was conceptual. That was the study of it. But later, I was fortunate because my husband was a lawyer. And therefore, I was fortunate to be exposed to the work that he was doing also. And I realized that when you get into practice, you acquire those skills. He himself was a law teacher. He went into law practice and he went to the top of the profession. So I don't think that law school should be focusing on teaching practical skills. Yes, certainly clinical legal aid and that kind of exposure. But what I would like to see is law uh, uh, degree programs giving a good foundational course, interdisciplinary, maybe sometimes, and then leaving the certification part of it, as in medicine, etc., to another body, which will take that on. And that's why I said I hope that the law colleges will also become a degree awarding institutions, so they will also have the same ethos without focusing on what they call practical training, practical subjects like evidence, civil procedure, etc., etc. Not in a practical sense. Yes, evidence, yes, civil procedure, but in a sense of an academic discipline and a practical subject where you don't focus on just the practical training. I mean, evidence is very conceptual, some of those subjects. And now law college is teaching commercial law, intellectual property law, international investment law. So what's the difference? So Chaturika, my answer to your question is to actually question the bifurcation.
Thank you, madam. So, picking from that, so how can collaborations between academics and practitioners enhance the quality and relevance of the legal education, madam?
I'm sorry, can you repeat the question?
Yes, madam. How can collaborations between academics and practitioners enhance the quality and relevance of the legal education?
Yes, so that interaction is absolutely important. It's very important because, as I said, it's very theoretical to suggest that lawyers. I mean, my husband did a case on medical negligence, and my goodness me, how much research he had to do to find out the Roman Dutch law. You see it in the judgments of many of our judges. Recently, there was a judgment by Justice Janakti Silva, many of his judgments. What a lot of wealth of research is incorporated in that. So lawyers are doing research, right? Judges are doing research, and now they get their juniors to do the research. So juniors are doing the research. So why are we saying that research, etc., is different, and that we need to bridge this gap between academia and lawyers? No, law fact they're in the current situation because of there's a bifurcation. We should strive more and more to connect academia and the bar. And I think this kind of program is very good because it is doing just that. It is bringing to the profession and lawyers and judges, etc., who may not be linking with academia, the academic voice is making the connectivity. And I think the faculties and the law programs are also doing that because many of the teachers in these law programs are practicing lawyers. You see, so they're also coming in, and when they come as practicing lawyers, they don't teach only things like evidence and civil procedure. No. They teach other subjects, investment law, corporate law, etc., which requires both that intellectual insight of research and thinking, as well as the practical aspects. So certainly, I think the linkage is important, but I would like to see it embedded in the approach to legal education. And that's what I'm missing here, Chaturika. It's not embedded in the approach to legal education. And that bifurcation is a disservice because law faculties and law departments also sometimes have to conform to what are the requirements of the law college for the final exam, for instance. So students say, no, I won't take human rights or environment law because I want to get to do a subjects which I'll get brownie points at the law college, right? Now that constrains also curriculum review in the universities. Why should that be? That's not necessary, right? And if you don't do that, then everybody will have that academic background of conceptual thinking, of research, learning, etc., go into the profession with that background without thinking of themselves as lawyers who are learning civil procedure, evidence, etc., to practice, and academics who are going for a broader spectrum of subjects. So I also want to say that one of the flaws in this kind of thinking is, apart from the connectivity, is that both practicing lawyers and academics are increasingly taking, increasingly, I mean, this is not something that has happened recently. I have experienced it in my own life. I mean, as an academic, one doesn't have to be limited to the courses that you teach. You have so many opportunities, Chaturika, and you should use those opportunities. You can use those opportunities in so many ways. You can, for example, contribute to public policy. Academics are becoming, Dr. Harini Amarasuri is an example. Academics can become legislators, go into politics. They don't have to be lawyers to go into politics, lots of lawyers. But academics have gone. Professor Viswa Varnapala from the university. So that's the path. Legislation, right? The corporate sector. How many academics are also giving advice and being accessed, intellectual property, etc., by the professionals? So that is an area they can, if and in my own case, this is how I went into so many other areas, which went far beyond teaching and research. Because the research that I did, I always felt should be used in public policy. And I had wonderful opportunities to do so with colleagues, for example, in the Center for Human Rights, in the Center for Women's CENWO, CENWO, Center for Women and Research. So colleagues were willing to understand that law and research could be used in public policy, in activism, in legislative reform. And therefore, academics today have all those opportunities and should use them. Because as I said, law is a central discipline. And it goes into all those areas. And therefore, one's role in teaching and in research must not limit the frame of the scope, limit the scope of your contribution, because you are basically a person with lawyering skills. And as I said at the very beginning, you can contribute to so much. And in my own experience, this is how I went from my focus on teaching and research in the university to the whole wider areas of human rights and development, and so many other areas where I found that I could use my lawyering to give me satisfaction and also make some kind of contribution to the society I live in. And I would like academics today who are teaching in the universities. It's not easy because today perhaps the demands on teaching are very different. You have to cope with AI now, which will really turn assessment on its head, which will require new thinking. You will probably be spending hours to figure out whether your students have plagiarized and copied something from somewhere. And so that's going to be just a waste of time. So there are lots of more challenges for you. But that being said, in terms of time management, it will be good if teachers cannot speak of themselves as just academics. And that already there are lawyers and judges who are going into doing research, not just in I think they have to do research if they're adding their judgments. A good judge will do the research and get others to help into the research or to research. Similarly, that will happen in the case of lawyers who want to make important arguments, particularly in the appeal courts, maybe not in the trial courts, but in the appeal courts. So that's happening anyway. But I hope that that should not be on the basis of collecting titles and degrees, but with a real interest in broadening one's perspective. And I hope that happens too. Postgraduate programs, unfortunately, are not so developed to have postgraduate courses. But I hope that these will also move from just giving certification, so that even people who do these advanced courses, postgraduate courses, will do it out of a sense of interest in those areas of academic research, rather than just to say, well, I've got an MPhil or a PhD or whatever it is, and that's going to put it on my career. It will be give me brown points in my career. I hope that happens because, again, that broadening of perspective is so important, and both professionals, practicing lawyers, judges, academics, actually should be in a single path of learning, Chaturika. A single path of learning, education, expanding the areas of your knowledge.
Thank you, Professor. That lays the foundation for my next question. So, Madam, as someone whose writing have been cited by the Supreme Court itself, what step do you feel can be taken to ensure that academic research become even more accessible and useful to practicing lawyers and judges? Now we are living in a virtual world and there are so many ways, means and methods that people can access knowledge. But what matters is sometimes there's a question as to the quality of materials that we are accessing. As you correctly pointed out, now we are living in an AI era and it has become challenging for not only for academics, for everyone, especially who are interested in genuine quality work. So, madam, what are your thoughts on that? How can we make it more accessible for judges and lawyers?
Yeah, I think one of the good things that has happened now is that because of the focus of the universities also on the need for research for career advancement, even within the universities, there is much greater focus on journals, contributing to journals, doing academic work, etc. So in the universities, I think this is happening. That is, in the universities, you have a focus on publishing, and I think one of the challenges, however, there is, again, once it becomes a career promotion path, sometimes, it's publish or perish, So then the focus is not on really doing quality work, and that's unfortunate. But there are lots of people who do very good work within the universities. And there are lots of practicing lawyers now, for instance, in areas like constitutional law. They are doing academic writing, and their books are being used. Now, accessing that is another problem, because one is that these books are not available in libraries. That's a serious issue. Some of the publications that I have written, 2 chapters in international publications, they are so expensive, I don't think even the libraries have copies. And I don't know their use. So, unfortunately, what is being accessed in terms of research is what is available on a Google search on the internet. So judges and lawyers, I think, already do through their young research assistants or the clerks who work in their chambers, they're accessing that material, right? But that's limited. That's limited. So unfortunately, therefore, a lot of work that is not on the internet, and not everything is on the internet, is not accessed. So access there is an issue of access to books, Chaturika, which is a real challenge. I don't know whether the law faculty in Colombo gets all the journals that they can. It's an issue of money. Do they get all the publications that have been done even in Sri Lanka? I don't know. So if then those books are not accessible, if those articles are not available, how do judges and lawyers cite those in their judgments? You see, in my time, there were few books, and lawyers bought those books. The Open University produced course materials, and those went into the system. We wrote course materials actually. Now some of them are just gone out of print. So accessibility to literature is important because increasingly, even in academic, in postgraduate work, I see literature reviews only refer to what is on the internet. So sometimes I given an article to review and I say, have you read this? No. Have you seen this article? No. These are frontline scholarship on these areas, but they have to get access. So that's an issue, Chaturika.
Thank you, madam. And given that now, madam, since you mentioned about AI, I'm deviating from our questions lineup. Now there's a concept called hallucination, AI hallucination, and apparently it has become a challenge for practicing lawyers and judges as well, because sometimes when you use all these generative AI apps, there are certain cases that have been made up, which are not really existing in the world. And I think, given that we have chat. Am I audible, madam? You're on mute.
Rain shower. So I think that's affecting the connectivity.
Okay.
So I didn't get that question. Can you repeat it, please? Now it's sort of
Yes.
slightly better.
Yes, madam. I'll speak a little louder for you. So,
Yes, please.
madam,
That's good.
so I'm slightly deviating from our lineup, but since you mentioned about AI and we are talking about accessibility of data and information legal research, now there's a new challenge has emerged because there's a concept called AI hallucination, because many young lawyers are using these generative apps such as ChatGPT and all. And what we see, even in UK and Australia, we have seen that there were certain cases they have cited which are not existed.
Absolutely. Absolutely. And I talked to a lawyer in the US, and this is what he said. He's a person who's practicing in a frontline firm. And we talked about AI. And I said, how do you know the validity of this information? Because sometimes what you do get is completely wrong and completely false. So how do you do this? And you know that in one case in the US, this lawyer cited cases from AI which were totally false. And the judge did his own research and found that they were false. And then he wanted him, professional misconduct action taken against him. And that person said, I'm sorry, my lord, I got this from AI. So how do you validate? What I was told is that one way of handling it is it's like they mentioned it is like you get instant information. So rather than going through all the legislation, the cases, the jurisprudence, etc., okay, you access it on the internet. But in making your arguments, in writing your essay or your research, you check it. Is there such a statute? Is there such a case? So which requires you to do the reading. What it facilitates is it cuts the time that you spend on your search. So it cuts the time that you spend on your search, the intellectual search for material. But then you validate it yourself. And if you don't do that, then it's a problem. But in teaching, now that's for the profession. So the profession, for instance, you can't just say Google search. It's like a Google search, but you go ChatGPT and access this material and say, okay, here is this course, I'll put this in. No, you can't. You have to validate yourself. At least that's what I understand, one way of handling it. Now that poses much greater problems for assessing assignments, you see. Because so many students, if you give essay type questions, that would be bad news because they'll all copy from the same source. So I think the whole method of teaching has to change, to cut down the weightage given to written essay writing probably increase much more the problem-oriented learning, the oral presentations, etc. We'll have to do that, because otherwise you would be spending your time trying to figure out what is authentic and what is not valid.
Sure, madam, that's true. So, madam, on that note, what advice would you offer to law students or early career lawyers considering a transition into academia? What are is there any checklist that you want to mention?
Can I ask you what you mean by transition into academia?
So, let's say there's an early career lawyer and they wanted to become a lecturer in a law teaching institute. So, like, is there any checklist that you want to suggest? Like, are there any basic qualities that they should possess apart from
No,
integrity?
I don't think so. Quite frankly, I don't think so. Because when I think of the people who went from teaching to practice and from practice to teaching, that flow has been continuing for decades. There are people who have begun, look at, after all, the first professor of law, Chaturika, in the Department of Law was Justice Suits. He was a judge and he was a professor of law. You see, Professor Nadraja was also a lawyer, though he was an academic. My husband was also a teacher before he became a practitioner. So, I mean, from my generation's point of view, it's difficult to relate to this concept of should you be a teacher or should you be a lawyer? I think it's a career choice. For example, I know of young people who have joined from the profession, the faculty of law. Why have they done so? Why? Because they have personally found that they want to do more in-depth work and study and research than practicing gives them time for. So they think we should go from practicing law into the university. So to them, I would say, and similarly, on the other hand, people teaching the faculty of law feel frustrated, don't want to think, don't think, I can't do this anymore because I don't like it, and they're going to practice and do very well. So I would question this bifurcation and say that we must not institutionalize it. What I see is, Chaturika, something that maybe you people suffer from, which we didn't. Because when we did law as a degree, everybody went to law college and they became lawyers. I went and got my I was enrolled as an advocate. Then I became on the transfer an attorney at law. But we never thought of ourselves as, people who did academics and not going into in completing our professional training. Because to be a lawyer, you need that, right? And sometimes there are disadvantages in teaching without any idea of what the practical dimensions are. I remember I used to teach custody, and I realized later that without the professional insights, we didn't even know that though the custody decision is made in the appeal courts, the actual decision goes to the magistrate's court. So if you're practicing, you might know that, but you might not know the academicism. So let's try to create an ethos where we all think differently. And we say that we must all link academia and the profession, cross-fertilize, network, etc. And I strongly argue for the institutional changes and the system change that will make it possible. Because as long as you have the separate law college and the separate, you will be again thinking in terms of this two-track. And that's a disadvantage for the young people who, would like to do both, for instance. And that takes me to another issue, which I think has not been addressed, the right of academics to practice. Teachers of law in institutions. Now, I hope if law college becomes also a degree awarding institution, maybe the whole ethos will change, right? It will change. But this question of why should not lawyers, academics, be also practitioners? I myself got permission from the University of Colombo to appear in 2 cases in the Supreme Court with my husband. Long ago, the chairman of the UGC, Professor Arjuna Alvihare, said, doctors are practicing, so why are lawyers not practicing? And Dean Professor Selvakumaran, Dr. Shirani Bandaranaike, and I, we were all colleagues at the same time. We were all at that time attorneys at law. He tasked us with taking up this issue, but I'm sorry to say we did not do that, right? And then there have been instances in University of Jaffna where the authorities came very hard on an academic who wanted to practice. So this has to be rationalized, and I think it should be rationalized because you cannot have, I do not think it's possible to have academics doing trial court practice. That's not possible because it's too, you can't take off from your teaching. If you choose the teaching path in a university, and I'm not saying that with this law college, if you are doing a teaching path, you do your classes there, but you can do chamber practice. People do it anyway outside hours, but you should be free to do that. And also, you should be able to appear in cases in appeal courts in a limited manner, limited number, limited manner. So this is another issue that has to be sorted out, which will then break down this idea that academia and legal practice and lawyering are 2 different tracks. And I hope that is also something which, as I said, I'm hoping that there will be institutional change. And if there is, and you move into that ethos, I think the kind of seamless flow between academia and the profession, which will be very much part of the legal education scenario.
Thank you, madam. So before we open the floor for
I would just to intervene. I just want to make 2 other comments, which if you will allow me, is that possible?
Yes, madam. Yes, we have
that is going beyond the Q&A. One, you asked me about what advice you have for people who want to come from profession to academia. And I said it should be choice based on what you think are priorities for your own career, your own intellectual growth, your own interest, and your career path, right? I think that should be it's a personal choice, and I hope it will be determined by what you want to focus on as a career path, right? And as I said, if you do come from practice into academia, I hope there will be a development which will permit you to combine practice. Not just teach as a visiting lecturer, but be on the permanent staff of an academic institution and also have some work in law practice. But I also want to say this, that once you are in an academic institution and you're a full-time employee, as opposed to a person who is a judge or legal practice, I think faculty individual staff have responsibilities to contribute to the institutional strengthening of universities. Today, we have systems which go back to the old Jennings era and our era with faculties, senates, councils. These are becoming completely dysfunctional simply because the whole ethos of university administration as a participatory exercise between academia and administrators has, I think, crumbled. Administrative decisions are made sometimes without reference to academia. And the wonderful kind of discussions, the vibrant differences in point of view that I experienced when I was in academic bodies like the faculty, the Senate, the council, I don't think is happening today. And that is also not happening because there is an environment which does not encourage freedom of thought, expression, ideas. There's a sense of hierarchy, top-down, non-participatory approaches in academic bodies. I hope that is not so in the governing bodies of the law college. I hope it is not so. But if it is so, then these institutions also cannot be the kind of bodies which can impact on teaching and learning, right? So I think that also is an obligation. If you join a university, if you're a faculty person, you are not just doing your research and your cheating. You are a member of a faculty. You are a member of a senate. And if you are in the senate, you should not be just looking at the buildings of looking at what's happening in your own faculty with your buildings, your courses, etc. But you should be interested in other disciplines. That's the kind of environment that I was privileged to work in. And sometimes my colleagues indicate that that is not so. So I would certainly say that if you choose a career path in academia, in institutions, please also contribute to the foundational values of academic bodies. You're seeing it today in, for example, the USA, where the Harvard Fellows have insisted that the university resists the attempt to stifle free speech. How did that happen? Because there was vibrant discussion. In our universities, by contrast, we have unions taking over that role, and academic bodies are not doing that. And similarly, I think the senates of universities, which under the Universities Act are the highest academic authorities, cannot function because now all professors go ex officio into the Senate. And on this, in the new senates, there are huge senates, which like Colombo has 300. How on earth can you have any kind of discussion? And when it's virtual, it's even worse. So university governance is important. And anybody who goes and transfers from law practice into an academic institution, I believe, has those responsibilities. And one final word, I think you have not asked that question from me, Satrika, and I would like you to ask that so I can respond to it, which is what you have to say to young practitioners and academics, right? So can you ask me that question so that I can conclude with that before you open it out for questions?
Yes, madam. Yeah. Before we move to the question and answers, so we will be opening the forum for question and answers. So if you have,
and then concluding with that, right?
Yeah.
That's fine. That's
So
that's great. That's good.
I would like to invite our audience to put it in the chat box so I can read it out to madam so she can respond. Madam,
Okay.
until they do it, I would like to ask this question. This is the last question in my list. What message can you impart to budding lawyers who wants to pursue a career in law? So because I know there are many students are they are joined with us
Yes.
because
I would say that law and education are two important central pillars of the growth and development of a country. And when you talk of law, today there's a lot of misconception about what are called liberal values, about democratic deficits, about the need for guided democracy. I would like all students who decide on a career path in law to understand the meaning and relevance of democracy as a form of governance. This is often confused with a Western colonial heritage. It's very interesting. We have not shed the negative aspects of Western colonial heritage in the legal education system, but we are quick to ask for shedding the Western tradition on democracy. Why? Because democracy as a form of governance was born out of suffering, out of human suffering, out of a serious conflict between power and the people and the exercise of power. Historically, that is so. So, yes, it has benefited from the Western Enlightenment. But I think we should remember that authoritarian governance was encapsulated in monarchy for centuries. And it was a democratic tradition that asked for accountability in the exercise of power. So let's not be confused that this is some kind of elite liberalism. No, It's a form of governance embedded in this country from 1948. And we have had bad constitutional developments which have taken away the balance between those three pillars, the legislature, the executive, and the judiciary. And that's why we're asking for constitutional reform today, because our country has suffered from the fact that you have had authoritarianism of the legislature in the 72 Constitution, the authoritarianism of the executive in the 78 Constitution. So I would ask all young lawyers to understand the enormous link between law and governance and to relate to some of those profound profound philosophical and ideological thinking, which should not be dismissed as either Western or something like that. I think that's very important. So I would ask that to do law, please commit yourself to that concept that the rule of law, the balance between the three pillars of governance, the franchise, all those things that you believe in your constitutional law are not something kind of superficial, not culturally relevant, indeed, to produce accountable sovereign. That's a responsibility of lawyers. That's a responsibility of people who go into law, because the rule of law is embedded in those concepts. And when we say rule of law, you have authoritarian governance, of course, forms of governance. You get it in communist countries, you get in other systems of governance. But we have had this other system of governance, and we must understand it and relate to it. And the other point is that it's very important to have a sense of social responsibility in whatever you do, whether you're in the university, whether you're a practitioner. So the moral compass and the ethics of your profession, the best of values in it, should also to be integrated in your personal life and in your practice and in your teaching.
Thank you, madam. Thank you very much. I think everybody present and who are watching us through YouTube will feel that our weekend has been so fruitful, because it feels like we read a book of 1,000 pages in these 1.5 hours. It is so satisfying to hear you, madam, and I feel everyone here and people who are watching us through the YouTube would share my sentiment. It seems it's worth it. Like, you feel blessed, and what a journey, what a charismatic character you are, madam. So on that note, let me invite all the participants. Please drop your question on the question and answer box, so we can pose it to madam so she can answer your question.
Yes, you're welcome. I'd be happy to do that.
Madam, here we go. There's a flood coming in. So there's one attendee asking, madam, what are the challenges you encountered as a young academic, and how did you overcome those? Madam?
I have to say that, again, my career was very much time-bound in terms of the fact, as I said, I was a daughter of independence with all the privileges that I had, with access to education, with opportunities, without the challenges that many of you face. So in a sense, it was an easy path. And I really can't say that there were kind of constraints and barriers that I had to overcome. But I realized very soon that that was also, as I said, time-bound. It was also the environment and context that we worked. For example, I never felt as an academic that the male lecturers were treated differently. We were just one or two women academics. We did not have hierarchy. We were able to talk to our professors and senior lecturers, both as friends and colleagues, and also challenge them. So there was this wonderful atmosphere of freedom of thought and expression. So there was no constraint in this, with that regard at all. And that was my experience as a young academic. So I can't say that it was in any way difficult. And as I said, that was because I was privileged to be starting my career at that at a time. And that was not just for me. All of us who were professionals, who were university academics, I think encountered that ethos. Later, it became difficult. There was a lot of politicization. And if there were constraints, it was a question of constraints imposed by bad policies, you know, sometimes student intimidation, etc. But I was able to survive that, and many of us survived that because of a strong collegiate environment within the universities. We might have had different politics. We might came from different groups, but on basic fundamental issues, there was collegiate connectivity. And so I really can't say that I had that kind of challenge or constraint either on the basis of gender or anything else. It was not, at least in my earlier career path, I don't think that happened. I also have to say that things changed later with the difference in language policies, the fact that, student numbers increased, etc. There were different kinds of challenges. And I think, and this is something I should have said in my concluding remarks on what lawyers can do. I should have said that. I had made a note on that, but may I repeat it now because you have asked this question with there were constraints. There were no constraints in terms of ethnicity, race, gender. But as things went later, we were also trapped in those differences of ethnicity, class, etc., which would entangle with politics. But that didn't affect our personal lives. It does today. And therefore, I believe that in the post-war years, lawyers have an enormous contribution to make to go beyond what the late Amartya Sen, sorry, not late, but Professor Amartya Sen, the great development economist, said that we don't have a single identity. We have plural identities. We may be Sinhala, we may be Tamil, we may be embedded in our whole cultures, but we like Western music, we like Western clothes, we like Japanese food, Thai food. We are a people of multiple identities. So we should recognize and celebrate that. And we don't do that. So lawyers have an important role to play, I think, young lawyers, in going beyond this identity trap, not a single identity. Professor Yasha Munk of John Hopkins University has written on this identity trap, because he says when you have a single identity, you can't connect. And that's exactly what Professor Amartya Sen, the development economist, said. So I think lawyers also have to think not as Sinhala lawyers or Tamil lawyers or, in different categories. And academics also, not on the basis of anything, but your intellectual engagement with this wonderful discipline of law. So to go back to the original question, no, we didn't have those constraints. There were pressures, but we coped with them also because of this very collegiate environment in which we live.
Thank you, madam. There's another question. So she asked, madam, in your experience, do you think it has become more difficult for young lawyers to navigate academics and also continue in the legal practice? What advice can you give in this regard?
That's really interesting, because that question is interesting because it shows that lawyers would like to be able to study, do some deep learning about the law, but their day-to-day practice doesn't really give them time to do that. So that, of course, I don't know. I have not had. I mean, I don't know what it is like to work as a young lawyer, or I don't know what in chambers like any of you do, or engaged in trial practice. But I can also talk from the experience of my husband when he had his chambers. There were his juniors who were engaged with him in the task of research because he practiced in the appellate courts. So if you're working with an appellate court lawyer, I dare say this issue will not be so difficult for you. So if you want to do that kind of deep learning, perhaps it's good to try to move from the trial court practice, which is also demanding, to working with a person with an appellate court practice and then getting these opportunities, or even working pro bono sometimes to assist judges and the judiciary, and especially appellate court judiciary. If that's at all possible, then you will get those opportunities. Because, as I said, I know that in my own husband's case, he had chambers and he was doing appellate court practice. And some of his juniors have gone on to do academic work. They have done publications, writing and research. So that's possible. But I don't know whether you can do that when you're a busy practitioner in the trial courts.
Thank you, madam. There's another question. It says, Madam, I have noticed that in many law faculties and departments, there seems to be a significantly lower number of male students compared to female students. What are your thoughts on the reasons behind this trend and how might it impact the legal profession in long run?
Well, this has been a serious problem and it's a new one, right? when I was on the UN CEDAW committee, and my colleagues there, it was called the UN Committee on the Elimination of Discrimination Against Women. That was a CEDAW treaty. I was a member of that monitoring committee on the treaty body. It could be the treaty body. And my colleagues would be shocked when I should tell them that in law schools in Sri Lanka, we have at that time, so in the 90s, 80%. Now it is 90%. When I go to the faculties, I can hardly find a student who's a male. Right? There are reasons for that, I think. One is a highly competitive examination process, where in the area of humanities and social sciences, the women outstrip the men. So they are the achievers who come in large numbers, right? And as far as the men are concerned, also they either go to the sciences, to medicine, to technology, to management, etc. And then they do not consider law a career path in that way because they have other options too. And even if so, there's a competition element there. And then sometimes even when men join the law faculty as teachers, they find that they could do better, have a better career path in practice. So they leave the faculty to become practicing lawyers. It has happened many times. They leave academia to become practicing lawyers, and they practice in the appeal courts and trial courts, and they choose the practitioner's path. That also happens. So there's an exit faculty at the level of teachers. So you have many more female teachers than male teachers in the teaching institutions. I'm talking of the universities and the public universities, not the private. But in the case of students, then there is the men choosing other career paths, and in the case of law, being displaced by the women who perform better at the examinations, and also the fact that they're not choosing this law as a path. Now, one of the problems with the women too is I remember going to the law faculty and asking, I was asked to talk on the legal profession and in the law faculty many years ago. And when I asked the majority of the large number of women who were there, what could you choose to do? They didn't want to go to the judiciary. They didn't want to practice. They said they want to stay home and write deeds. And I was shocked. And I said, look, you are getting a state education, right? 4 years in a law school. And at the end of the day, this is your contribution to stay home and write deeds. I said very soon there'll have to be affirmative action for men. And certainly there might have come a time when you will have to have affirmative action to ensure the gender balance in the law faculties and the legal education institutions, because it is unfortunate that this is so. So the system of admission to universities also should be changed drastically, right? To ensure that law teaching institutions attract a balance of men and women. So this examination system also is a kind of cutoff. And yes, it has serious implications because you need a gender balance. I mean, that's so in any, you don't want you don't want a complete dominance by one. You'd like to have a gender balance. It's a good idea to have that. So we have to work on that. And I agree with you. It's a huge, huge problem which has not been addressed.
Thank you, madam. And there's a compliment. I think it's from a student of OUSL, and she says, as an LLB student of the OUSL, I'm so grateful for the preparing of OUSL course materials, which continue to guide and support us in our studies. So, madam, may I ask what was the planning or thought process behind coming up with this kind of idea? So, to say that, okay, let's prepare some course material.
Yeah, that again is something which has not been addressed. Fortunately, when we started the OUSL course, it was distance learning. So therefore, the face-to-face in-class interaction was extremely limited. We were told that we were not going to have we were not going to have in-person classes. I, of course, insisted at the beginning that we could not go completely virtual. We had to have the discipline of law required that kind of personal interaction. And therefore, the early batches you will have heard had a strong element or strong number of in-person courses. That was changed later, and I believe now it is minimal for you. But part of that exercise was therefore, because there was no teaching in person, you had to give student materials. And at that time, there were no materials published or printed. So the Open University started the concept of having course materials. Now, in the Faculty of Law, I'm sorry that the people have contributed a lot in terms of research articles, journal articles, publications, books. As I said, many of which are not accessible to students, but they've hardly produced the kind of written course materials which they should be producing, like in the Open University. I have not looked at the quality of the recent publications by the Open University for course materials, but if you tell me that they're good, that's very good. But that concept of giving teaching materials, I think, is a very important one. And you should encourage teachers who teach courses to put down their materials in print form and do books and to give this kind of information to students as course materials. I think that is doable and it should be done. In fact, my first book, Udgalanithya, was basically my Sinhala medium lectures. And sadly, it's still being used after how many decades? But it shouldn't be used because it's outdated. So we need to produce materials, Chaturika. And I think that can be written in to the task of students just as much as in the Open University. Of course, you have made much more. I think it's also this whole idea of the administration must recognize that the teaching task of students, of teachers, must not be such that it stifles everything else. They must not be overloaded with courses by having too many courses in the curriculum. It's better to have a lean curriculum, better to give teachers time to do the teaching, to write course materials, and have a balanced program, not to overload them with so much that they have no time for producing this kind of teaching material, which of course Open University staff do have. They have the time because they don't do the in-person teaching.
Thank you, madam. And There's one question. Could you kindly suggest any suitable further studies or program? I think they are referring to the postgraduate studies for individuals who are interested in supporting and helping children.
Well, there are postgraduate programs, I think, in the other faculties, like I'm sure Department of Sociology, Psychology, etc., must be having these what they call diploma courses or certificate courses, etc. I'm not aware of them. I know that the postgraduate program in the Faculty of Law has a course on children's rights.
Yes. Sure, madam. So now that takes us to the end of this wonderful session. And thank you very much, madam, for your valuable time and your thoughts, which always inspires us as like female academics and academic in general. Thank you for your valuable contribution to the legal education of this country. And I know you have so many first under your name, and it will take us a week or month to discuss about everything. But unfortunately, as everything else in this life, we have to put a full stop to certain good things as well. And I would like to thank you, Bar Association of Sri Lanka and Mrs. Indika Isuri for this wonderful opportunity for me as well. This is a time well spent. And now I would like to hand over this forum to Kulani. Over to you. Thank you.
Thank you, Madam Chatrika. This brings us to the end of the first webinar of the new series on professional, personal and career development titled Bringing Academia and the Law Through the Eyes of a Legal Academic. I would like to thank our esteemed panelist, Professor Savitri Gunasekara, and our moderator, Mrs. Chatrika Kurugadu, for the fruitful and the educational discussion and for the dedicating your time to be here with us and sharing your insights. Also, I would like to thank the BSL Women Lawyers Professional and Career Development Committee and the BSL Webinars and Legal Symposiums Committee for their dedication and hard work in organizing this insightful webinar. And last but not least, I would like to thank all of you who have joined in for this session today through various platforms and for the interactive discussion that we have had. Thank you and hope